So we're going to have a look here at one particular case involving a school and the Human Rights Act. Now, this is a real case and this is a summary sheet, and then I'll give you some more information. So the child is known as C, and it's against Wigan Borough Council 2011. So C is an 18-year-old boy who had been resident in a school for some years. He has autism and severe learning disability with extremely challenging behaviour. His behaviour was managed in large part by the use of a padded room in which he was secluded when he exhibited challenging behaviour. He had developed a number of behaviours that were particularly prevalent when in the blue room, including defecating, smearing, and eating his own urine and faeces and stripping naked. He was prevented from leaving the blue room for reasons of aggression and nakedness. The blue room was also used as a room to which C had been encouraged to withdraw as a safe place. So the summary of the findings: when the child C was secluded in the blue room, he had been unlawfully deprived of his liberty. It makes clear that when a young person of 16 is to be deprived of their liberty within the children's home or residential school, an application for lawful authority must be made prior to the deprivation of liberty taking place. And where a young person does not have a mental disorder within the meaning of the Mental Health Act, as a matter of good practice, the Mental Health Act Code of Practice should be applied. So this raises some issues for schools who are using seclusion areas. So whatever you call them, if it's a room where a person gets taken to or goes to, then we've got to look under the issues to do with Article 5, deprivation of liberty. So Article 5 of the Human Rights Act. So I'll just read you a little bit more which came in relation to that case. So for the purpose of background and context to the case, in England and Wales, the deprivation of liberty under Article 5 of the Human Rights Act is unlawful unless it is authorised by the Court of Protection or via a paper-based exercise known as the Standard Authorisation that adheres to the Mental Capacity Act of 2005. So one of the topics that we train in as well is the Mental Capacity Act and deprivation of liberty safeguards. And we're going to have a little input in relation to those further during this training. Guidance in relation to support for people with mental health needs issued by the Department of Health 2008 defines seclusion in the Code of Practice Mental Health Act 1983 as the supervised confinement of a person in a room. Its sole aim is to contain severely disturbed behaviour which is likely to cause harm to others. So that's page 34 of the Department of Health 2008 guidance. The supervised confinement of a person in a room, its sole aim is to contain severely disturbed behaviour which is likely to cause harm to others. The Code of Practice, Mental Health Act 1983, also states that prolonged or repeated use of seclusion would be an indication to consider formal detention, and states the importance of distinguishing between seclusion and the use of time out and other behavioural and psychological therapies. The issues came to the forefront in the case of C, who was severely autistic and had profound learning disabilities. His behaviour also challenged the service that supported him. C's behaviour was suggested to be uncontrollable, and as a result, this was largely managed by the way of the padded blue room, in which he was secluded when exhibiting challenging behaviours such as defecating, smearing, and drinking and eating his own urine and faeces, aggression, and stripping naked. He was not permitted to leave the blue room when this happened. The court was required to consider a number of issues. Most significantly, what was good practice to be adopted in relation to his nakedness and the use of seclusion and restraint, particularly the impact that the blue room had on his quality of life and well-being. In considering this, the court had to decide whether C was subject to inhumane and degrading treatment, and also whether his right to liberty and respect for his private life had been infringed. The court also noted that if the blue room was to be used, the school had to be clear it was only for as long as was necessary, that it was proportionate, and that it was the least restrictive option. The judge confirmed that an intervention and prevention plan for the use of the Blue Room and a document advising upon the management of C's nakedness was to be agreed. He also confirmed that seclusion was not to be used solely for the reason of his nakedness or as a punishment to manage C's behaviour, or on the basis that C was self-harming. The judge concluded, as a consequence of the findings, decisions and approvals made by the court, detailed orders and declarations under the Mental Capacity Act 2005 have been made, providing for C's interim placement at the school, but under very clearly defined procedures and constraints, in particular concerning his seclusion. His liberty may be deprived in very limited circumstances and only with the authority of the court. So again, we cover these kind of issues about managing of behaviour in a separate course in itself, but it's another thing to think about in relation to child protection and what's going on your side. Because if use of such areas can be shown to be unlawful and can be harmful to the child who's been subjected to them, then therefore there's some internal abuse which may be alleged. Now, also in relation to these kind of rooms, I myself have been used as an expert witness for several cases which are still working their way through the legal system. So if you've got any particular questions about the behaviour management, then please don't hesitate to make contact. But we will cover some of the issues around deprivation of liberty further on this course. And we'll see you on the next input.